In today's episode, we're going to speak about why it matters that there is a deep reset happening within the crypto landscape and what this means. So, in July 2023, SEC versus Ripple revolutionized the landscape by critically examining and presenting the court ruling that has provided so much regulatory clarity on whether a digital asset is a security. And this ruling itself, which we're going to analyze today, speaks about what are the parameters for it falling within the ambit of a security and what does not fall within that ambit. And we look at basically the court's ruling, the judgment itself, which we're going to analyze. Here you're going to read the exact judgment and understand the deep reset that has occurred within the next 10 minutes. So here it goes. Just going to pull this to the side. Let you see this. Okay, here we go. Okay, so the SEC brings its action against defendants Ripple Labs and two of its senior leaders, Bradley Garlinghouse and Christian A. Larson, alleging that defendants engaged in the unlawful offer and sale of securities in violation of Section 5 of the Securities Act of 1933. This is the United States District Court, Southern District of New York, SEC versus Ripple Labs, Bradley Garlinghouse and Christian Lawson. And we have Judge Torres, who this ruling has been written by and this order is issued by this court. Before the court are the parties' is cross motions for summary judgment, and the SEC's motion is granted in part and denied in part. So in 2011 and early 2012, Arthur Britto, Jared McCallett, and David Schwartz developed the source code for a cryptographically secured ledger or blockchain, which is now known as the XRP ledger. They aimed to create a faster, cheaper, this is the purpose of XRP, a faster, cheaper, and more energy efficient alternative to the Bitcoin blockchain, the first blockchain ledger which was introduced in 2009. XRP is the native digital token of the XRP ledger. What is XRP? XRP is the native digital token of the XRP ledger, and the XRP ledger requires XRP to operate. Each unit of XRP is divisible into 1 million drops, and each unit or drop of XRP is fungible with any other unit or drop. Of the 100 billion XRP generated by the XRP ledger's code, the three founders retained 20 billion for themselves, including 9 billion for Lawson, and provided 80 billion XRP to Ripple. The founders did not sell any XRP before the launch of the XRP ledger, and Ripple never owned the 20 billion XRP retained by the three founders. Ripple has said that its mission has been to realize an internet of value by using technology to facilitate the transfer of value across the internet. Specifically, Ripple seeks to modernize international payments by developing a global payments network for international currency transfers. Now we see that Ripple has launched its RLUSD, which is a stablecoin, and that is in accordance with the exact legal premise of this ruling. For instance, Ripple developed a software product called RippleNet, which allows customers to clear and settle cross-border financial transactions on mutually agreed upon terms. The feature it offers is on-demand liquidity, and it facilitates cross-border transactions by allowing customers to exchange fiat currency for another fiat currency. The XRP ledger is based on open source software. Anyone can use the software and the ledger. Anyone can use the ledger, submit transactions, host a node to contribute to the validation of transactions, propose changes to the source code, or develop applications and run on the ledger. Other developers have built software products that use the XRP ledger, such as payment processing applications, also funded companies as part of its Spring initiative, Xpring initiative to incentivize the development of other use cases. At all times before the end of 2020, Ripple owned between 50 and 80 billion XRP. First, Ripple, through wholly owned subsidiaries, sold XRP directly to certain counterparties, primarily institutional buyers, hedge funds, and ODL customers pursuant to written contracts. This formed institutional sales. Ripple sold approximately 728 million of XRP in USD valuation. Second, Ripple sold XRP on digital asset exchanges programmatically or through the use of trading algorithms and programmatic sales. Ripple's XRP sales on these digital asset exchanges were blind bid ask transactions. Ripple did not know who was buying the XRP and the purchasers did not know who was selling it. The SEC alleges that Ripple sold approximately 757 million of XRP in programmatic sales. So there's institutional sales, there's programmatic sales, and then there are other distributions. Right here, there are other distributions which consist of various employee compensation schemes, including funding third parties to develop applications. In addition to Ripple's sale and distributions, Larsen and Gardinghouse offered and sold XRP in their individual capacities. From at least 2013 through 2020, Larsen sold XRP on digital asset exchanges programmatically and made at least 450 million from the sales. From 2017 through 2020, Gardinghouse sold XRP on digital asset exchanges. The SEC alleges that Gardinghouse sold approximately 150 million XRP during this period. And during this period, Ripple did not publicly file any financial statements or other periodic reports, nor did it make any EDGAR filings, which are mandatory for securities. Further, the essential part of the ruling here is that there was a law firm memo circulated that did state that there is some risk, albeit small, that the SEC disagrees with the analysis that XRP tokens do not constitute securities under federal securities laws, given that there is a lack of case law on this and a lack of precedent. There is further clarity that is required. The more the founders and Ripple promote XRP as an investment opportunity, the more likely it is that the SEC will take action and argue that XRP tokens are investment contracts. So, procedural background. On December 22, 2020, the SEC commenced this action. Moving further, at this point, summary judgment is asked for by both sides. Summary judgment is appropriate. This is a procedural part of the law where the record shows that there is no genuine dispute as to any material fact and that the moving party is entitled to judgment as a matter of law. A genuine dispute exists if the evidence is such that a reasonable jury could return a verdict for the non-moving party. The moving party initially bears the burden of demonstrating the absence of a genuine dispute of material fact by citing evidence in the record. If the moving party meets its initial burden, the burden then shifts to the opposing party to establish a genuine dispute of material fact. Under Section 5 of the Securities Act, it is unlawful for any person, directly or indirectly, to offer to sell. This is the violation itself. Offer to buy or purchase or sell a security unless a registration statement is in effect or has been filed with the SEC. To prove this violation, the SEC must show no registration statement was filed or in effect, and that the defendant directly or indirectly offered to sell or sold the securities. Number 3, through interstate commerce. So specifically, the SEC alleges the defendant sold XRP as an investment contract, a type of security defined by the Securities Act. Here we come to the very important Howey test, where the Supreme Court held that under the Securities Act, an investment contract is a contract transactional scheme whereby a person, number 1, invests money, number 2, in a common enterprise, number 3, led to expect profit solely from the efforts of the promoter or a third party. And analyzing whether the contract transactional scheme is an investment contract, form should be disregarded for substance, and the emphasis should be on economic reality and the totality of circumstances. Here, what was found, which are essential to this ruling, is that notes use of the word profits and how it was intended to refer to income or return. And financial returns or investments are not equivalent to profit sharing. The definition of an investment contract is a contract of scheme for the placing of capital or laying out of money in a way intended to secure income or profit from its employment when fashioning the relevant test. Here the Supreme Court's ruling was applied, and Ripple's test that they wanted to apply was explicitly rejected as being unsupported by legal precedent. Investment contract means contract, transaction, or scheme. Here it is important that the court has specified even if XRP exhibits certain characteristics of a commodity or a currency, it may nonetheless be offered or sold as an investment contract. So the allegations were that institutional sales, programmatic sales, and other distributions, which we just discussed what those categories comprise of, are all problematic. Here the court distinguished between institutional sales and the remaining programmatic and other distribution sales by establishing the fact that the second prong of Howey establishes a common enterprise, whereas here the first prong establishes whether investment of money was made. Here the institutional investors put in money by providing fiat or other currency. They also signed contracts to the effect that they could not resell those particular digital assets for a certain time period, meaning that they were not specifically for exchange of currency as a store of value. Horizontal community, horizontal commonality exists for a type of commodity, involves pooling of assets from multiple investors so that all share in the profits and risks of the enterprise, meaning the second prong of the Howey test, a common enterprise. This was also met where it came to institutional sales, but not for the rest, meaning institutional sales must be bifurcated, and what has been done is that they have been brought under the traditional finance model. Thereafter, an entire plumbing infrastructure has been set up. So the third prong of Howey examines whether the economic reality surrounding Ripple's institutional sales led the institutional buyers to have a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. Profit means an income or return, for example, dividends, other periodic payments, and the increased value of the investment. Here are the crucial elements that Ripple and its senior leaders publicly emphasize the complexity of creating an internet of value and to uphold and create an ecosystem. Applying the totality of circumstances test, it was decided that Ripple's institutional sales constituted the unregistered offer and sale of investment contracts in violation of Section 5 because some of the contracts expressly stated, as I mentioned, that the institutional buyer was purchasing XRP solely to resell or otherwise distribute and not to use XRP as an end user. Some of them were required Ripple to be indemnified, and it is obviously apparent that any rational economic actor would not agree to freeze millions of dollars if the purchaser's intent was to obtain a substitute for fiat currency. This is to be contrasted with that of the other categories. An institutional buyer knowingly purchased XRP directly from Ripple pursuant to a contract. But the economic reality is that a programmatic buyer stood in the same shoes as a secondary market purchaser who did not know to whom or what it was paying its money. So the bids and the transactions were made not even knowing who the actual seller was, and there was no decision, conscious intention to invest in the Ripple company itself. The relevant inquiry is whether this speculative motive derived from the entrepreneurial or managerial efforts of others. Many programmatic buyers purchase XRP with an expectation of profit, but they did not derive that expectation from Ripple's efforts itself, particularly because none of the programmatic buyers were aware that they were buying XRP from Ripple. This is a critical distinction, that the programmatic sales were not made pursuant to contracts that contained lockup provisions, resale restrictions, indemnification clauses, or statements of purpose, unlike the institutional buyers mentioned previously. The brochures, the marketing materials that were submitted were done for institutional buyers and not distributed to the general public. And that kind of high level knowledge is only accessible by someone who is a sophisticated buyer, which would be the institutional buyer here.